Welcome to Introduction to Environmental Law, Module 10, Achieving Compliance Through Enforcement and Other Means. In this module, we are going to consider enforcement as it largely relates to the activity of corporations. And before we do that, we need to understand a few basic principles about corporations, why they exist, and what role they have in terms of industrial and other activities. Corporations are legislated entities, and their purpose, as stated in legislation, is to maximize the benefit to shareholders. Traditionally, the benefit has largely been considered to be wealth maximization, but more recently, it is seen to include matters of corporate and social responsibility and environmental awareness, taking a longer-term vision. The activities of corporations often cause harm to the environment, and corporate law is generally regarded as being unfriendly to environmental concerns because it is designed to protect shareholders from liability, and it mandates that corporations operate in their own best interests. Compliance is the end, the goal. Enforcement is a means to achieve that goal. Compliance refers to the achievement of a prescribed process or standard, observation of a standard or rule imposed by law. And enforcement is any action to determine whether or not compliance is being achieved or to respond to non-compliance. Enforcement is only effective when it is timely. Various international agreements may impose obligations for enforcement, such as Agenda 21 or NAFTA. Enforcement is more than punishment after the fact. It includes the process of creating binding standards or imposing liability, accountability for ensuring compliance inclusive of the obligation to comply, the duty to enforce, and the right and responsibilities associated with exercising enforcement powers. Compliance objectives may be made binding through statutes, regulations, license, or permit, or a compliance agreement where provided for by law. It may be administered through departments, boards, and tribunals, court directives, or orders. Accountability for compliance with prescribed codes of conduct is also a critical determinant for liability and compensation. Failure to understand the significance of enforcement in the environment and development equation may relegate sustainable development to a theoretical construct. The courts will consider whether government have all of the elements on this slide in place and whether they have been used by enforcement officials before the courts will consider issues of liability or impose a penalty on an accused. Relevant to a piece of legislation, such as the Canadian Environment Act, there needs to be a statement of intent to enforce. There needs to be clarification of powers to enforce, such as inspections, search, and seizure, and a description of players and their roles, who can do what, who can act as an inspector, who can launch a prosecution, and what forum is appropriate for considering the charges laid. When developing a compliance strategy, it is important to understand the proposed standard to be achieved. Is it reasonable? Can it be complied with? What is the cost of compliance, and who should bear that cost? In some situations, it is appropriate for the public purse to support some or all of the costs involved, but usually it will fall on the company to pay for compliance costs. There needs to be a full cost accounting for implementation of an environmental standard or objective, which requires that consideration be given to all the necessary associated costs. A compliance strategy can clarify who and what should bear the costs of implementation. Who are the targeted parties? What is the appropriate role for various publics or direct beneficiaries? And there should be integration of public interest groups, industry associations, and the insurance industry in particular, where voluntary compliance is part of the strategy. What relationship exists between enforcers and other government officials? When we are talking about departments of the environment who work on a regular basis with industries, the custom is to separate the role of the enforcement body from that of the administrative body to avoid conflicts of interest. We are now going to look in a little more detail at 3 different elements of compliance strategies other than enforcement. When I say other than enforcement, I mean enforcement by government officials. Under the Criminal Code, anyone who on reasonable grounds believes that a person has committed an offense may commence a prosecution by swearing an information, the charge. Under the Canadian Environmental Protection Act, any 2 persons resident in Canada who are not less than 18 years of age and who are of the opinion that an offense has been committed under the Act may apply to the Minister for an investigation of the alleged offense. 3 issues with private prosecutions are: the prosecution may be stayed, that is, paused, or may require the prior permission of the Attorney General or Minister of Justice to proceed. There is a tremendous informational, technical, and financial burden to secure a conviction for pollution offense violations. Because the prosecution is often initiated in situations where there is perceived to be too cozy a relationship between the government regulator and the offending industry, the actions of the government official may be seen to be on trial as much as those of the accused. Effective voluntary measures do not occur in a vacuum. Without sound regulation, a credible threat of enforcement, and a supportive public, voluntary measures will either wither away or be ineffective. The actual and potential costs of making voluntary improvements, legal, financial, marketing, etc., must be less than the total cost of not making them. The elements listed on this slide may be characterized as market forces to promote good environmental citizenship on the part of corporations. As noted earlier, corporations have begun to pay serious attention to their environmental profile because they have seen it translate into real value in terms of the public's acceptance and appreciation of a corporation's efforts, which will often translate into a better bottom line on the balance sheet. Non-regulatory instruments are methods used by government, short of legislation, regulation, or policy, to promote good environmental practices. Examples of these are shown on this slide, and the motivation or rationale for this approach extends beyond government's responsibility into the larger public domain. The overarching advantage or disadvantage of the alternatives set out on this slide lie in the fact that it allows corporations to take charge and responsibility for the changes that they will implement and gives them choice and control over the process. Beyond non-regulatory instruments or voluntary initiatives, there needs to be the realization that should these not be effective at achieving the goals desired, there is a legal fallback, and that these initiatives may, if warranted, be translated into a legislated regime. Environmental legislation includes the opportunity to use economic levers to achieve desired ends. Two types of economic instruments in use today include fixed price measures and tradable emission rights, or cap and trade. Fixed price measures are tax and subsidy incentives to reduce pollution. These can take the form of emission taxes, subsidies for reducing discharges, or allowances when discharges are reduced. A criticism of this approach is that fixed price measures do not limit or cap the total amount of pollution. Tradable emission rights represent specified quantities of emissions that are issued to polluters and that may be traded between or among them. An aggregate cap, or baseline, on allowable emissions is divided into units, which are allocated to the polluters based upon emissions history. This baseline is often set too high and results in a redistribution, but not a reduction of pollution. Administrative decisions are made by government officials or tribunals pursuant to a statute that sets out the decision-making process. Decisions can be made by a government employee or a cabinet minister. Applicants are usually required to inform and engage members of the public and to provide feedback to decision-makers, but public hearings are not common. Decisions made by a relatively impartial decision-maker, a tribunal or a board, typically involve some form of hearing. The public hearing procedure is similar to that in a court, but is usually less formal, with a more relaxed set of rules governing procedure and evidence. As noted, informal processes are quicker and less expensive than formal judicial processes, allow for a broader range of evidence and sources to be admitted, but they may be less fair and impartial. Natural justice, procedural fairness, is the fundamental concept of administrative justice. Common law rights of procedural fairness apply and fill in any gaps unless specifically changed or excluded by statute. Three main elements of procedural fairness are reasonable notice of proposed decision and key issues against affected parties, a fair opportunity to be heard, orally or in writing, and an independent and impartial decision-maker. Tribunals must, as their statutes require, reach explicit final decisions. Written reasons for their decisions are also often released, although this is not always a requirement. Some tribunals have the authority to force unsuccessful parties to pay the costs of successful parties. Some tribunals also have the power to award participation funding, whether participants win or lose. There is no automatic right to appeal an administrative decision. An appeal must be provided for in the enabling statute. Where a right to appeal is provided, sometimes it is necessary to receive leave to appeal before presenting a case. Two forms for appeal include appeals to another administrative tribunal, a superior body to the tribunal which made the original decision, or appeals to court. And there are two types of appeal. Appeals de novo, new hearings where everything is reheard and reconsidered and new evidence or arguments may be presented, or appeals on questions of law and jurisdiction, no new evidence, and it is limited to appeal on legal grounds. Various provinces have established specialized tribunals to hear appeals from administrative decisions, such as the Alberta Environmental Appeals Board or Ontario's Environmental Review Tribunal. Operators against whom orders have been made and individuals who meet statutory standing requirements have a right of appeal to these boards as set out in their legislation. The advantages of environmental appeal boards are that members have specialized expertise in the topic. There is a less formal procedure, often established by the board itself, and they usually include a well-developed mediation process. The main disadvantage is that sometimes, as in Alberta, appeals are subject to approval by the Minister of the Environment. It is possible, although not easy, to challenge board decisions in court. The grounds for judicial review are narrow. Courts may deny judicial review if they are satisfied that an adequate alternative remedy, such as an appeal to an environmental appeal board, exists and has not been pursued. Standing for judicial review requires the following. First, that there is a serious legal issue to be determined that affects the applicant directly. Second, that the applicant has a genuine interest as a citizen in the decision. And finally, that there is no other reasonable and effective manner in which the issue may be brought before the court. Reviewing an administrative decision involves one of two standards of review: correctness or reasonableness. Any legal considerations must be correct in their outcome. Any factual decisions must be reasonable as determined by the initial decision maker. The standard of review is the depth of review done by the court and reflects how much deference will be afforded to the administrative decision maker. When determining which standard of review applies, the court looks in particular at whether the tribunal interpreted its empowering statute at any relevant case. It also considers whether or not the statute contains a privative clause, a clause specifying that the decisions should not be subject to review by the court, the expertise of the decision maker. How knowledgeable are they about the matter at hand? Whether it is based on a policy decision as opposed to a technical matter. Policy decisions are political, as the name suggests, and are not subject to judicial review. Implementation of policy decisions may be subject to judicial review. And questions of law versus questions of fact. Is it a matter of interpreting the enabling statute, or is it a matter of what actually happened as the statute was applied in the decision? Because procedural fairness involves legal rights, the standard of review is based upon procedural fairness as interpreted in common law, and it is always necessary that it be correct in its expression. A court may find that an environmental decision maker has made a reviewable error on grounds such as that it is substantially ultra vires, that the subject of the decision was not within the power of the decision maker to make, given the terms of the enabling statute, that the decision maker exhibited either real or apprehended bias, that the decision, in other words, was not made impartially, that the process for arriving at the decision breached the basic terms of procedural fairness: notice, a right to be heard, and a right to an impartial decision maker. The three remedies available, which are based on the prerogative powers of the court, that is, those powers which still exist within the context of the Constitution, are either mandamus, where the court rules that the decision maker should take the following actions to correct their error; certiorari, that the decision should be quashed or overturned; and a declaration as to what the proper state of the law is in relation to the question being asked of the administrative tribunal. Any or all three of these outcomes may result in the decision being sent back either to the original decision maker or to another body for rehearing and reconsideration. There is no guarantee that at the end of the day there will be a different outcome. Prosecution under the Criminal Code is available for the worst offenders and carries with it the potential for fines or incarceration, and with the associated social stigma that those will bring. Mostly what we are dealing with in terms of environmental issues are what is known as regulatory offenses. And in the case of the Queen versus Sault Ste. Marie, Chief Justice Brian Dickson set out 3 types of potential regulatory offenses. Those classified as mens rea, or criminal offenses, where the prosecution must prove both the act and the intent. Absolute liability offenses, those offenses where the legislature has determined that once the facts of the offense, the occurrence, has been proven, then a penalty must be imposed. And finally, and this is the most common type of offense, those known as strict liability, where it is open to the accused, once the prosecutor has convinced the court that the accused is responsible for contravening the terms of the act or regulation, they may put forward arguments as to why they should not be held liable or why liability should be reduced. And the most common of these is the defense of due diligence, where an accused has taken all reasonable practical grounds to avoid the occurrence, and yet the contravention did take place. To show due diligence, one must establish an effective system to prevent offenses, to monitor that system, and improve the system if problems recur. The greater the potential for harm, the higher the requirements in terms of exercising due diligence. On this slide are listed many of the underlying rationales that influence sentencing. In the landmark case of Keno Mines, the judge considered the role of many of these elements in determining what is an appropriate sentence in relation to the offense. The role of government is also important. The courts will look at what steps the government took to inform those affected by legislation of their obligations and how active the government was in achieving compliance.